Mhm. All right. Hello, everybody. Hi, and welcome to our webinar, Friday, November 21st, 2025. You've joined an HOA forum organized by the Colorado Division of Real Estate's HOA Information and Resource Center. My name is Amanda Lopez. My role here in the HOA Center is the HOA Program Assistant. Joining me today is Nick Altman, the HOA Center's HOA Information Officer. And also with us is David Donnelly, the Education, Communication, and Policy Manager with the Division of Real Estate. Hi, David. Thank you, and happy to have you with us. All right. Before we begin, I'd like to go over a few housekeeping items. This webinar is being recorded, and the recording will be uploaded at the end of today's forum, just FYI for all of you. The Q&A feature that we have has been enabled for this presentation. So if you look at the bottom of your Zoom interface panel, you should see a Q&A icon where you have the option of asking a question. So if you prefer to remain anonymous, while doing so, you have the option of selecting the Ask Anonymously box. Again, we really appreciate everybody's engagement and questions today in the forum. To be as efficient as possible in answering your question today during the webinar, please take a moment to check that the current list of, sorry, I apologize. Please take a moment to check the current list of questions that are being submitted in the Q&A to see if another attendee has not already asked your question earlier. And this is just to avoid any duplicate. We're making sure and we're making every effort to ensure that we can continue producing these live presentations in the manner that we have been. So again, if you can please help us by carefully considering whether your question has already been answered in the Q&A. Likewise, also please ensure that your questions are related to the topic of today's webinar, which is special assessments in HOA communities. And with that, let's go ahead and jump into it. So I'd first like to explain who we are and what we do. So the HOA Information and Resource Center was created by statute and exists to serve as a resource for consumers to understand their basic rights and responsibilities under the Colorado Common Interest Ownership Act, which is also known as CIOA. The HOA Center also registers common interest communities and tracks complaints. What we cannot do, we do not mediate nor do we arbitrate on behalf of homeowners, board members, or community association managers. We do not act as a regulatory program, and we do not provide legal advice. The HOA Center does not investigate nor do we intervene in any disputes that arise between homeowners or HOAs. Or the associations, I apologize. The HOA Center does not act as an advocate. We do not assess fines or penalties. We do not enforce an HOA's failure to register. And I know we have a, I apologize if I went ahead. I think I may have missed what we do and don't do. I apologize. I think I kind of went a little bit ahead of myself. Just to go over what we do here in the HOA office, as opposed to what we do not. We provide information to homeowners regarding their basic rights and responsibilities, again, under Colorado Common Interest Ownership Act, also known as CIOA. We gather, analyze, and report information through complaints and HOA registration. We create resource materials, provide educational forums such as the one that you're joining today. We provide a website with information for the public. The HOA Center also registers HOAs pursuant to 38-33.3-401 of the Colorado Revised Statute. And lastly, we provide an annual report to the legislator. Okay. And getting more into it, in our efforts to carry out the mission of this office, we try our best to remain balanced, independent, and unbiased when responding to these inquiries and educating the public. So with that, I'm happy to pass the baton over to Nick. Nick, go ahead and take it away.
All right, thank you, Amanda. Just as a quick disclaimer too, the information in this presentation is not intended to be construed as legal advice, and our forums are for educational purposes only. So as Amanda mentioned, the topic of today's forum is HOA special assessments. So I wanted to start off with the Colorado General Assembly's legislative declaration, which is what the state of Colorado believes is in the best interest of Colorado's citizens, and how we ought to frame our thoughts and opinions around homeowners associations and how we should move the conversation forward. So the legislative declaration, which is found in Kiowa, the Colorado Common Interest Ownership Act, states that the continuation of the economic prosperity of Colorado is dependent upon the strengthening of homeowner associations and common interest communities financially through the setting of budget guidelines, the creation of statutory assessment liens, the granting of 6 months lien priority, the facilitation of borrowing, and more certain powers in the association to sue on behalf of the owners. So the state of Colorado has determined that HOAs have this authority and this power to operate themselves. HOAs also have the ability to collect delinquent assessments from homeowners, as well as, in addition to the setting of budget guidelines, to adopt and amend budgets for revenues, expenditures, and reserves, and to collect assessments for common expenses from unit owners. So it's in the best interest of the state of Colorado to ensure financially sound and strong HOA communities. And this declaration is found in Kiowa Section 102. So as we see, one of the main purposes of HOAs is to manage budgets and finances. And this duty is taken care of by the executive board of directors, and it's the board of directors' responsibility to create the annual budget, to understand its operation, and to understand the finances and the needs of the community. The association assesses dues upon the unit owners for its operation based upon the approved budget. Again, the board of directors is responsible for making sure that enough income comes into the association by way of these owner dues in order to meet its operational expenses and reserve requirements. So board members have a fiduciary duty to collect HOA dues from unit owners to ensure that the community is ran properly. So the HOA Center did previously have an HOA forum on HOA budgets, and I dropped a link there on the slide if you're interested in getting more into the details of how the budget process ought to be, what the protocol is to follow when the board is adopting and approving a budget, and how to present the budget to the unit owners at the budget ratification meeting. So I encourage you all, if you have not already watched this video, to visit our website where we post our recorded videos. So just as a high level overview of what the budget process is real quick, and this is pertinent to both pre-Kiowa and Kiowa communities in Colorado. So Kiowa sets forth that HOAs need to follow the process for creating and passing a budget for the association, which first involves drafting and adopting a budget. It also involves providing notice of the adopted budget to the membership, and it involves setting a meeting for the association members to review and consider a veto of the budget. So importantly, in Kiowa states that unless a majority of the owners veto the proposed budget, or any higher percentage as set forth in the declaration or the governing document of the HOA, the proposed budget becomes the approved budget of the association. Additionally, associations can require owner approval of the budget as allowed by Kiowa. So importantly, the HOA and the board has to allow the unit owners and the homeowners to an opportunity to veto the proposed budget according to Kiowa. Associations also have the power to amend their budgets for revenues, expenditures, and reserves. So for limited expense communities, which is another type of community, but there are not too many limited expense communities in Colorado. For these communities, Kiowa does not define the budgetary requirement, but the governing documents most likely will. So I just wanted to make sure to include that. So with respect to like what type of what type of assessments do we commonly see in HOA communities? We have regular assessments, or what most people commonly understand to be HOA dues. These are usually paid on a monthly, quarterly, or annual basis, different periodic payments, and they are used to cover general operational costs in the community, including expenses like maintenance, landscaping, legal fees, registration fees, insurance, and other general operational expenses incurred by the community. So these regular dues differ from regular assessments differ from special assessments, which are less frequent and made on an ad hoc or as needed basis. They're used to cover unplanned large expenditures, such as the replacement of a common element, such as a swimming pool, or maybe the HOA needs to replace the heating pump in the swimming pool. Large unplanned expenditures, also new construction. Also, you might see a special assessment used to replenish the HOA's reserve account. So just a little bit more about regular assessments in Colorado. The HOA Center does commonly receive the question, what is the average HOA due in Colorado? Or dues? Is there a figure that represents the average HOA dues in Colorado? And the answer is no, because every community is different and unique with respect to the community's age, its size, the number of units, the nature of its amenities, and so on. Although you might find sources online that show average dues to be somewhere in the range between $200 to $400 in Colorado. Again, this range varies, especially if you consider mountain communities and more rural communities. So executive boards they do have the authority to raise dues as they deem necessary or fit in order to meet the operational requirements as set forth in the approved budget of the community. So if you're an executive board member on this call, just know that you have substantial power when it comes to running your community. Now, keep in mind that some communities may have limitations or, quote, a cap for how much the board may raise dues in any particular year. For example, maybe your governing documents say the executive board may not raise dues by more than 5% per annum, or dues may not increase by an amount that exceeds the consumer pricing index from the Department of Labor and Statistics, some kind of language like that. So it's important to review your governing documents to determine if such a cap exists. Most governing documents permit the executive board to increase dues by majority vote of the board. So just the board itself can vote to increase dues. However, keep in mind that Kiowa does require homeowner input. It allows homeowners to speak before the board votes on increasing dues. So if the board is considering increasing dues, it has to allow for homeowner input. And it needs to consider how is it allowing homeowners to speak or have their voice be heard prior to the vote. So while the Colorado Nonprofit Act permits boards to take action without holding a meeting, just like as I said, and it's worth repeating here, Kiowa still grants to unit owners the opportunity to speak on an issue before the board votes on that issue. Looks like I duplicated that bullet point on accident. Okay, so in addition to, so we've learned that the board has to allow homeowners to speak before an issue. What the board is allowed to do is to enact reasonable time restrictions on persons speaking during the meeting. So what constitutes reasonable? So the HOA center is not able to make that determination. However, generally, we see 3 to 4 minutes per homeowner to speak on an issue, to voice their concern, support, or opposition to a vote or an action. Um, is 10 seconds or 15 seconds reasonable? Probably not. Is 12 minutes reasonable? Probably not. But you just want to make sure that the opportunity to be heard is there. Banning, muting, or otherwise preventing homeowners from attending online Zoom meetings may lead to liability. So more about special assessments. How are special assessments due? Sometimes you'll see them due on notice, the time when the homeowner receives the notice in the mail, when it's time stamped, postmarked. So when the notice is received, sometimes it's due on notice. You might also see special assessments payable in installments. So maybe monthly payments due every month. So an HOA's governing documents will likely dictate how soon a board may require payment of a special assessment. Keep in mind, Kiowa does not speak to how soon a board may require payment of a special assessment. It does not say homeowners are required to pay a special assessment upon receiving notice or anything like that. However, a board should carefully consider, I'll speak to this more in some later slides, but can the homeowners afford to make the payment if the board is requiring a direct lump sum payment immediately? Can the homeowners afford to make that payment? The board needs to consider these questions. So similar to the procedure for increasing regular dues, an HOA executive board in most cases may levy a special assessment through majority vote of the board. In other words, when I say a majority vote of the board, owner approval is not required in those cases. So some limitations may exist in the HOA's governing documents. Closely and carefully check your HOA governing documents to ensure that if the board even has authority to levy special assessments. Two, if the board has authority for that particular purpose to levy a special assessment. And three, any other restrictions that may exist with regard to levying special assessments. Again, similar to a board voting to increase assessments, because a vote is required, owners must still be allowed to speak prior to the vote. For both actions, voting for increasing dues and special assessments, again, the board must also make sure to properly memorialize the action or vote in the meeting minutes at the meeting in which the vote occurred. So the vote has to be reflected in the meeting minutes. While the Colorado Nonprofit Act permits a board to act outside a meeting, Section 7, 127, 107 does set forth very specific requirements a board must follow if it chooses to go this route. I do not know all the particulars of how a board may act without a meeting, but I do know that the board members all must agree that they are about to take action without a meeting. If you would like to learn more, please refer to Section 7, 127, 107 of the Colorado Nonprofit Act. So who pays for the special assessments? Generally, special assessments are spread evenly across all the unit owners, although you may see some communities levy it against specific groups of unit owners, such as maybe unit owner 3 or C enjoys access to a limited common element like a balcony or a storage unit. So again, check the association's governing documents for authority and how the assessment may be levied. Again, worth repeating, any authority to levy a special assessment on homeowners must be found in the governing documents. In most Colorado communities, once a special assessment has been approved by the board must follow the Kiowa budget ratification process found in Section 303(4) of Kiowa, which, as I previously mentioned, includes mailing a budget summary to all owners. Apologize, I didn't actually mention this part, just the notice, but it includes mailing a budget summary to all owners within 90 days and to hold a meeting to allow for an owner veto. So sometimes, the HOA Center receives inquiries about how can we audit the board, or, does Kiowa speak to conducting financial audits or financial reviews? So it does speak to it, and it's important to kind of understand what the language is saying here. So according to Kiowa, at the discretion of the executive board or upon owner request, the books and records of the association shall be subject to an audit using generally accepted auditing standards to be performed by a certified public accountant. Now, it does not say does not say whether or not the CPA may be employed by the community manager or not. Kiowa does not go too specific into that question. All it says is that it has to be performed by a certified public accountant. If an audit is requested by the owners of at least 1/3 of the units represented by the association, in order for that owner requested audit to occur, the association must have annual revenues or expenditures, one or the other, of at least $250,000. And the Kiowa statute citation is included there on the slide if you would like to review it yourself. As an alternative, an HOA may request a review, which uses statements on standards for accounting and review services by an independent and qualified person selected by the board. And this comes directly from Kiowa, which person shall have at least a basic understanding. Oops, my screen got a basic understanding of the, can't read that, as a result of prior business experience, education above the high school level, or bona fide home study. Sorry, my Zoom interface was interfering with my slide there. All right, so considerations for the board. First of all, determine if a special assessment is, again, granted authority in the governing documents. Do you, as an executive board of an HOA, have authority to levy a special assessment? And the answer will be found in your governing documents. 2, is homeowner approval required, or can the board proceed without approval? Oftentimes you see communities, they need the additional funding to cover maintenance expenses, rising costs, insurance premiums, insurance deductibles. Sometimes the community absolutely must levy a special assessment to meet these operational requirements. So the governing documents will dictate whether homeowner approval is required, which is a higher ledge to climb up on for the board, or can the board just vote to proceed without that homeowner approval? The question, will the cost be spread out evenly among all the unit owners, or do the governing documents allow for different groups to be levied in accordance with the community, with the common elements? One lump sum payment, or periodic payments. So what are some tips and tricks to help the board communicate and obtain homeowner approval when it's petitioning or trying to approve or issue a special assessment? For one, it's a very difficult and contentious procedure. Not many board members I know enjoy raising dues or levying special assessments. Nevertheless, HOA board members have a fiduciary duty to care for their communities and to ensure the financial soundness. So tip number 1 is to be transparent about the need for the funds. What is the added revenue going toward? What will it go toward? And how will this special assessment help the community at large? If the determination is made that, hey, we must levy this special assessment, do your due diligence and conduct thorough research about the expenditure and the project. This kind of goes with just basic project management, but helpful tips is to define the project's purpose, conduct a feasibility or financial study, document your deliverables. So how are you going to communicate progress to the homeowners? Set your objectives. What are some potential roadblocks or pitfalls that the board may face? Um, Understand how to allocate the resources in order to get this project done. You might also want to measure the performance against some sort of plan, and again, address any shortcomings. And then finally, inform homeowners of when and how the final product will be delivered. So, this all sounds really fancy, but when will the pool be ready to use? When will the grills be replaced? Uh, Give homeowners a concrete time frame and timeline on when they can expect their hard-earned money to be realized. Communicate early and communicate often. So be upfront and just come up straight with the homeowners and say, hey, we need additional funds. We're seriously considering either increasing dues or some sort of special assessment. Please attend this meeting and give us your thoughts on this project, on this expense, and what you think as a group of homeowners we ought to do. Provide a feasible plan, um, uh, a payment schedule. Provide a feasible payment schedule. Can you expect your homeowners to make a $6,000 payment payable on December 1st before the Christmas holiday? Is that a reasonable expectation or goal for the board? Determine if the project is truly needed. Can a compromise be made? Like, do we have to replace all the roofs, for example, or does our insurance policy dictate that only, if a claim is filed, that only roofs on buildings A, B, and C need to be replaced by 75% or something like that. Consider the overall impact that the assessment's going to have on the community, and try and figure out if some sort of compromise can be made that both parties will agree to. And then lastly, and perhaps most importantly, is to seek input from professionals like architects, engineers, and accountants. The board is permitted to rely on professional opinions, and even if a case goes to litigation, if the board can prove that they were relying on a professional opinion, then they may find safe harbor, or they may have a defense in court if it ever makes it to litigation or a lawsuit. Again, communicate early, communicate often. I think I already duplicated this slide. Let me advance here. All right, so are there any a different scenario that the board might consider instead of levying a special assessment is, hey, as an HOA, we do have the authority to incur debt or take out a loan from the bank. Most covenants do allow for the board of directors to borrow money and incur debt on behalf of the association. Its power is also explicitly granted in the Colorado Nonprofit Corporation Act. So things to consider when deciding whether to take out a bank loan is, how is our delinquency rates currently in the community? Do we have pretty low delinquency rates? And also, are we able to pledge our future assessments as collateral for the bank to secure against the loan? Section 312 of Kiowa does require 67% of membership approval before subjecting the common areas to a security interest. Therefore, be sure to check your governing documents prior to working with a bank for a bank loan. So what about the concepts of reserves and the reserve study? So just more broadly speaking, a reserve study is an examination conducted by a reserve specialist, some sort of consultant like an HOA management consultant or business consultant or an accounting firm, for the purpose of analyzing any probable long-term expenses in the community. And they do specialize specifically in HOA communities. So the analysis is then used to estimate the association's reserve needs as accurately as possible. Oftentimes we get the question, are HOAs in Colorado required to conduct a reserve study? The answer is no, HOAs are not required by state law to conduct reserve studies. Previously, legislative efforts have attempted to mandate the use of reserve studies. And I believe that was House Bill 22-1387, which was introduced in the 2022 General Assembly. This bill would have required reserve studies, but ultimately it did not become law. Now, however, just because reserve studies are not mandated or required does not mean that the association still does not need to have some sort of policy in place, which indicates when the association has a reserve study prepared. How frequently a study should be prepared, or whether or not it even conducts reserve studies. Two, whether there's a funding plan for any work recommended by the reserve study, and if so, where are the funds going to come from to pay for the reserve study? And then three, whether the reserve study is based on a physical or financial analysis. So these concepts need to be in the association's reserve study policy. This is required by state law. Also, in addition to the reserve study policy, Kiowa requires a policy on the investment of reserve funds. So how the board may invest the reserve funds, or even if the board is allowed to invest the reserve funds in the first place. These two policies on reserves and reserve funds are part of the 9 required good governance policies as found in Kiowa, section 209.5. So how are reserves how can the board use reserves? So an HOA's reserve fund is an account dedicated to unanticipated and deferred expenditures, especially the large ones. So the association allocates money towards its reserved account over time, so that when a large expenditure becomes necessary, the board has those funds to use to address those items. And unless generally speaking, the use of reserve funds is at the discretion of the board, unless the governing documents require membership approval. So for board members, they are under a continuing obligation to act in the best interest of the community. And this obligation is set forth in the Colorado Nonprofit Corporation Act, that's section 7/128/401. And that states that the board has discretionary authority, provided they're acting in good faith, with the care an ordinarily prudent person in a like position would exercise under similar circumstances, and in a manner the director or officer reasonably believes to be in the best interest of the nonprofit corporation. So as an elected volunteer board member, you are subject to these legal principles. So what are some possible alternatives to levying a special assessment or to increase cash flows in the community? So probably number one is what's referred to as working capital contributions. And these are essentially a one-time payment collected from each new owner upon closing. You'll see this more and more in Colorado as a way to replenish the reserve account and ensuring that the community can meet its budgetary goals and requirements. Typically, you'll see 1 to 3 months assessments up front at closing as a requirement to close. So this could be a particularly useful tool to use in communities with a higher turnover, or in communities with seasonal occupancy. For this tool, for working capital contributions, the authority must be granted in the declaration. If no authority exists, then owner approval would be required through an amendment to the declaration. Just a couple other few suggestions on ways to increase cash flow. A board may consider renting or leasing community property, such as if it has a common element like a clubhouse or a lakefront dock or some other sort of space that's authorized for social gatherings or recreational purposes, the board can consider renting it or leasing that space for additional revenue. It might be good to consult with legal counsel just to help with planning, and it could be a good way to utilize that additional revenue source. Another option is to sell space in the community newsletter to advertisers. If your community has a robust and a highly circulated newsletter, it could be a very interesting way to raise additional revenue by selling ad space in those newsletters. You might consider reaching out to local businesses to determine if they have any interest in advertising in your community. Another option is to charge a facilities fee. So things like using the swimming pool or the spa or related facilities cost money. And again, this could be a way to raise additional revenue. So the idea behind this is that the cost will be paid through usage. Maybe you have a swimming pool, maybe you have a common element that's not particularly used a lot. So instituting some kind of reasonable access fee or usage fee might be something to consider. Consider investing your reserves. Make sure that you're following your reserve investment policy. But and again, you might consider retaining the services of a professional, like a professional accountant or certified financial analyst, somebody like that with a professional designation. And look to your community's policy to determine how viable investment of association funds may be for your neighborhood. And then I know this is kind of a, who can cut costs in this economy, but maybe the board just wants to consider cutting costs somehow. It's worth reminding yourself that a trim budget can make all the difference when it comes to association finances. So I want to include some tips for homeowners who may be, trying to learn more about their HOA, and maybe you've been confronted with a special assessment or you've seen dues raise significantly in the past couple of years. To be quite frank, many Colorado communities have been forced to raise their dues just based on our economy and expenses going up and the cost of labor and materials increasing. So it's been very difficult on boards to continue to offer the same services, the level of service that homeowners may have been accustomed to without increasing dues. So if you're a homeowner, I think it's very important to educate yourself on your HOA and put yourself in the shoes of the board members and also the community manager, and ask yourself, okay, would I do this differently? I see how they're kind of running things. I think meetings should be ran at X date at Y time, or with the following procedures in place. Ask yourself, could I do it better if I was in that position? So the first tip I would offer here is to participate in the affairs of your community. That means attending board meetings, becoming active, showing that you care in the things that are going on in your community. Attend social gatherings, especially the annual meetings, the annual homeowners meetings, and then especially that budget ratification meetings. If you want to enact change, you need to make your presence known. You need to offer presence. Educate and inform yourself by thoroughly reading your HOA governing documents. This goes without saying, but you would be surprised how many folks I've interacted with who have no idea that their community is ran by a set of governing documents. These include the Declaration of Covenants, the CCNRs, the bylaws, the Articles of Incorporation, the rules and regulations, and governance policies. So we did also run. I produced an HOA forum on Governing Documents 101. I would encourage you to check that out as well by visiting the same link that you saw earlier in this presentation. That was on February 28, 2025. Read and become familiar with the Colorado Common Interest Ownership Act, or Kiowa. Many libraries, if you don't have a computer or access to the internet, many libraries have a copy of the statutes, and you can pull up Title 38, Article 33.3, Section 101, and start to acquaint yourself with the law that governs the community that you live in. When expressing your point of view at meetings, be courteous and respectful to your neighbors. I won't say anything else. Just that it's simple. I mean, courtesy and respect go a long way in voicing your opinion and in trying to bring others to your point of view and to your side. Adhere to your HOA's conduct of meetings policy. So, I know you might be very passionate about an issue. Control your write down your thoughts is what I found to be helpful. Write down what you want to say, and ensure that you're giving your audience the respect, and that you're adhering to any time constraints or other restrictions that might be laid out in your conduct and meetings policy. And that, remember too, that finally, the board members are volunteers. Oftentimes they're not paid and their efforts go unnoticed and unappreciated. So keep that in mind as you're attending meetings and expressing your point of view. I had one more bullet point here. HOAs, as I'm sure all of you know, HOAs already suffer from negative public perception. So I think it requires all of us to educate ourselves and participate and engage in order to combat this negative public publicity. So if a homeowner believes the board is not acting in good faith, probably the first good step is to talk to the board, to open up a line of communication, a communication channel with the board. Sometimes this means picking up the telephone, picking up a phone instead of emailing back and forth. Messaging very often gets conflated or misinterpreted in emails, and sometimes just picking up the phone can make a world of difference. Talk to the community manager. They're in this as much as the homeowners and the board is, and they have a tough job. So if a homeowner wanted to reach out to the community manager just to introduce themselves or thank them, they're looking forward to working with them, I'm sure your community managers would very much appreciate that. And then talk to your neighbors and introduce yourself to your neighbors and let them know that, hey, welcome to the neighborhood. We're looking forward to serving this community together. If the issue needs to be escalated, speak with an attorney. True, it does cost money. Not a lot in life is free, but one option is to consider engaging an attorney with a group of similar interested homeowners as a potential way to cut those attorney fees. Another option is to call a special meeting of the owners. This right is granted through Kiowa, and it permits the homeowners to call a special meeting by following certain steps. Of course, one option always available is to just remove the board. This is a very contentious option for all parties involved, but it is still an option nevertheless. This process is set forth at Kiowa Section 303.8. And then finally, refer the board. You can always refer the board to the HOA Center for assistance, for information and resources about Colorado HOA law and more information on basic rights and responsibilities. So some tips for board members. Communicate the need to increase assessments well in advance of the budget ratification meeting. A reserve study may help in identifying the need to increase dues. Again, reserve studies are not required, but if you're finding your all of a sudden expenses to be increasing, and maintenance items are going deferred, or maybe you're getting a lot of homeowner complaints about the common elements needing to be fixed or repaired, it might be a good time to consider conducting a reserve study for your community. And then consider whether a special assessment is absolutely necessary or not, as opposed to obtaining a loan from the bank. Again, consider your delinquency rates and any collateral for the bank. Again, offer a structured payment plan. Does the special assessment have to be collected immediately, in 2 weeks? And can our homeowners afford this special assessment? So, obviously, the HOA Center is cognizant and aware of the insurance challenges that HOA communities are facing, in terms of securing insurance coverage and trying to figure out how to pay for the insurance premium and insurance deductibles. Our sister agency in the Department of Regulatory Agencies, the Division of Insurance, has an excellent toolkit available that specifically addresses HOAs and HOA insurance. I highly recommend checking out this webpage. It contains great information, as well as a presentation of recordings that have occurred with stakeholders the past year or so with respect to the affordability challenges faced by Colorado HOAs. It also contains registration links on how you can participate as an HOA member or HOA board member. If you want to participate and offer your commentary as a member of the public, you can register and sign up I have it on the next slide for the next meeting, and make your voice heard and your concerns heard. The stakeholder meeting is on December 2nd at 2 p.m. Mountain Time, and the study is referred to as the HOA and Lodging Facility Study, as required by House Bill 24-1108. And I did include the link to register via Zoom there on the screen for you. Okay, so thank you very much for attending. I wanted to see if we can get to our Q&As here. And bear with me while I pull up our. Amanda, David, did you want to address any Q&As?
For my unmute there button there. Sorry for the delay. There's only one question in the Q&A right now, which pertains to the removal of board members. This question says the Nonprofit Act says all directors can be removed, but our bylaws say that only 2 out of 5 can be removed in a special meeting. And they're asking about which of those would prevail. And I'm not able to answer that question off the top of my head. Many of you probably that are familiar with the interchange and exchange between the statutory law and your governing documents, it would matter whether or not that statutory language, as well as your governing document language, has any deferential language, such as notwithstanding what the Nonprofit Act says, something about removal or whatnot. So I can't answer that question off the very top of my head here. However, if there, I would look for some language in the statute there to see if there is any deferential language, or if it states that that no matter what the governing documents say, the statute prevails. So devil's in the details, unfortunately, on that one. I apologize about not having that statutory language right in front of me at the current time.
All right, I know we had some questions answered in there already. I think I'll give 10 minutes back to your time today on this Friday, and end the webinar. Thank you all very much for attending this important topic on HOA special assessments. And if we did not get around to answering your question, please feel free to drop us an email using the email address on your slide. So thank you all very much for attending, and I hope you all have a very great weekend. So thank you.